It's an honor and a privilege to be able to present as a part of your Global Mobility Journey program. Thank you to the audience for taking time out today to listen to our presentation. When you signed up for this particular event, you might not have realized that this is the day before all the H-1B cap registrations have to be submitted. So as I was logging into this, before I turned my email off to devote my full attention to the seminar today, we're still having some clients finding out that they had F1 OPT interns that they needed to enter into the H-1B cap lottery this time around. So after this event ends today, may I suggest that you send out a blast email internally to find out exactly that, if you have any last minute people that need to be entered into the H-1B cap lottery, because tomorrow's the deadline. Several questions have been asked about the H-1B cap process, which I will answer during the course of the event. So for those who don't know me, my name is Brandon Meyer. I'm the founder and principal of Meyer Law Group, a law firm specializing in employment-based immigration, headquartered in San Francisco, with additional offices in San Diego, New York, Charlotte, North Carolina, and for our overseas audience, Ho Chi Minh City, Vietnam as well. I founded Meyer Law Group in 2010, and this is my 25th year anniversary of being involved in the immigration law process. Time flies when you're having fun, apparently, because I didn't quite realize it's been 25 years, but it has been. So, Andy, to answer your question, what do I find most fascinating about U.S. immigration law? And it's probably, somewhat counterintuitive. It's not its excitement. It's not its fast pace. It's not its change, although that's a part of it. It's the fact how the framework of U.S. immigration law is basically unaltered for the past 200 years or so. So the next time you're in New York, I suggest that you go visit Statue of Liberty in Ellis Island and do the tour. And as a part of the tour, there's a backdrop of how the process worked for people entering during the Ellis Island days of the late 19th century and early 20th century. If you look at how they describe the employment-based immigration process and the family-based immigration process and the rules and regulations, they're basically exactly the same as they are today. We have new, concepts. We have perm, we have this, we have that, but effectively, the labor certification process of 2023 is effectively no different than it was in 1867. And so that's what I find fascinating, is that, we think everything in immigration law is fast-paced and always changing, but the reality is that we're still dealing with a basic framework of a system that was established 200 years ago. And so definitely a good tour. Definitely recommend it to anyone, especially in this field, who has not been. So with that, I'll go straight into some of the excellent questions that we have received. And so the first question I'll address is, definitely a hot topic in mobility circles, pandemic and post-pandemic, and that is the remote office scenario. Some companies, of which actually Meyer Law Group is one of them, are now fully remote. And that's great. But the question is, if we're fully remote, how does this work for our H-1B and L-1 employees? Do we need a physical company address for our H-1B and L-1 employees? And so for your H-1B employees, the answer is no. H-1B employment allows for full remote work. Now, this leads to potential compliance nightmare for many companies, because if you have your employees all over the place, each one, they have depending on where they live and whether they're in a different metropolitan statistical area, they may have higher prevailing wages that, and that the company may not be willing or able to provide. For example, for software engineers and computer tech people, the LCA wages in San Jose and San Mateo are significantly higher than they are for San Francisco. There's only 30 miles difference between the two. But if you look on the Department of Labor website that tracks prevailing wages, San Francisco prevailing wages in the computer field are significantly lower. So what does that mean for companies? So if you have someone who's working remotely from San Jose or Menlo Park, then you might actually have to give them a $20,000, $30,000, or $40,000 raise to meet prevailing wage requirements that you wouldn't have had to meet had they been coming to the office in San Francisco. And then the compliance nightmare also continues that if your remote employees rent their housing and don't own it, they may be moving every year. One year they may be in Fremont, the next year in Pleasanton, the next year in San Francisco. And so if they move outside a different metropolitan statistical area, you may have to file H-1B amendments for your employees every year. As an immigration law firm, we love that. It's more fees to us that basically they do very little work just because someone moved into a different statistical area. But when you start adding legal and, more importantly, U.S. government processing fees, it becomes very, very expensive very, very quickly for companies that want to do the full remote work model. So permissible for H-1Bs, but a compliance and organizational nightmare as a result. For L1s, it's a little bit of a gray area. And my feeling is for L1B, specialized knowledge employees that are transferring from an overseas entity to the U.S., it's probably fine to have your L1B employees work remotely because they're coming to share their specialized knowledge with the particular company. Now, I think some consulates and USCIS may push back on L1A, multinational manager remote workers, because let's say you have a company in the UK next to Andy and a company in the US entity here in San Francisco. Andy's remotely managing a group of employees here in San Francisco successfully from the UK. Okay, well now we filed to move Andy to New York. Andy wants to go live in New York. So he's going to be remotely managing employees from New York. Well, if I'm a consular officer or USCIS, I said, well, wait a minute. Why, if the whole purpose is to transfer Andy to the US to work more closely with his team, then he needs to be closer to him. Having a remote worker in that context isn't actually doing anything that's different than their current scenario. So I think companies will run into problems with L1A remote workers. Definitely good practice is to put them at a designated company work site if you have one. Now, for a lot of people on the call, companies will have L1B blanket petitions. Those workers must absolutely be placed at a company site that's listed on the approved blanket petition. Not addressed as a part of the question, but we see this more and more, is remote companies that are fully remote running into problems with green card sponsorship. Because the green card sponsorship, aka the PERM program, is all about the company saying that we tested the U.S. labor market to look for specific occupations at a specific location, and we could not find any. So if the company's based in Menlo Park, the employee is working remotely from their apartment in, say, Chicago, Illinois, well, where's the job opportunity? Is it in Menlo Park or is it in Chicago? Good question. So what prevailing wage do we use? Do we use the Menlo Park address? Do we use the Chicago address? Great question. You say, well, the worker can work anywhere in the U.S., and I see law firms trying to do this, and that creates a whole mess. And the Department of Labor does not like to pushes back on fully remote work in the PERM context, because basically, if you open it up to the H-1B employee that you're sponsoring for PERM, then you need to open it up to anyone, anywhere in the U.S. workers that are willing to apply. So if you say it's okay for H-1B worker to work remote from Chicago, then why isn't it okay for a qualified U.S. employee or U.S. worker to work remotely from their house in, say, Fayetteville, Arkansas? It's a very, very difficult case to make. And then it is even more credibility issue, because if you're saying that yes, we are really testing the labor market to look for someone. So what if you found someone in Chicago that's qualified for the job? Would you force that person to work in the house or the apartment of the employer sponsoring? No, of course not. So, for obvious reasons, the remote work trend has been trending in that direction. I feel I'm starting to see a little bit of this, a bit of a reaction. So I think in 5 years' time, 3 to 5 years' time, we probably won't be discussing this remote company issue anymore, as companies gradually either call their existing employees back to the office, or just kind of under the radar reestablish set job locations. So keep that in mind. So we have a question from Marissa Johnson. Marissa, I haven't seen you in a while. Good to connect with you again. And that question is, we have heard that there may be more immigrant visas available for this fiscal year, which ends September 30th. When are we going to see movement in the visa bulletin for EB2 and EB3 China? This is definitely a question that's very, very important to many of your foreign national employees. And unfortunately, my prediction is that we're probably not going to see too much forward movement in EB2 or EB3 China or India anytime this fiscal year. We may see some movement in August and September, but I don't think we're going to see as much significant movement as we did 12 months ago, which means that we're going to have a lot of disappointed employees, as basically they'll feel like they've gone backwards in their quest to get a U.S. green card. And I think what a lot of people don't quite appreciate is that these visa numbers, and how they're allocated and how priority dates move backwards and forwards, it should be a science, but it's more of an art. The gentleman who used to run the visa allocation program for the Department of State, a gentleman by the name of Charlie Oppenheim, he retired about a year and a half ago. He had that job for 30 plus years, and he would come to various immigration forums and talk about his job and how he arrives at numbers to move on the visa bulletin. And I heard him admit on several occasions that basically he was just guessing. He was just making things up. He was working with very, very incomplete data sets of visa demand from both USCIS and the consulate and embassies overseas. Combine that with the fact that the U.S. government, by law, cannot issue more visas per fiscal year than are allocated. So basically, the way that they would deal with that, if he thought that that the U.S. government was issuing visas at a faster pace and that they would run out before September 30th, then he would just arbitrarily basically set the priority dates back way, way back in time to basically a place where they knew or reasonably assumed that there was no demand for. And so that's why you see kind of these violent lurches back and forth on the visa bulletin sometimes, because they're basically, the visa office is working in the dark and they can't issue more visas. And so the way that they do that is they just artificially cut off the supply. And so we will never, ever truly know exactly where we are with 100% accuracy, know where we are in priority dates relative to visas. And so, that just creates a lot of, anxiety and uncertainty for your employees when they wake up around the second week of the month when the visa bulletin comes out and they see their priority date go back 2 or 3 years. And it's very difficult to explain to them that's an artificial correction, because you can see it right there on paper. Unfortunately, unless the visa allocation system changes to more real-time data, which it probably never will, this is a problem that will probably, unfortunately, never go away. So with that level of optimism, Marissa, I'll answer your second follow-up question is what to expect from Department of Homeland Security in fiscal year 2024, which starts this October 1st. As you can imagine, being in this field for so long, I'm generally very critical of how USCIS, Department of Labor, Department of State, the entire U.S. immigration bureaucracy goes about its business. And that pessimism and criticism will probably never fully abate. But I have noticed here in the last 6 to 9 months, USCIS, DHS at least, coming out like they did yesterday and basically confirming what has been common practice for ability to pay in the I-140 context. And last week, confirming everyone's understanding of how 60-day grace period for H-1B layoffs works. So, those have been existing kind of understandings for a long, long time, but I think USCIS deserves a lot of credit for going on record and putting these out there so that everyone knows what the actual understanding is. And see a question here. We recruit perm for HQ out of corporate, and no matter where the person, even if remote, and then, okay. Yeah, well, good thing about that, Marissa, is, things like that succeed until they don't. And usually when they don't is when you come in one day and you have a bunch of perm audits on that issue. So, that's a good thing about immigration. One of the other get to later, this is very, very true in immigration law. If you ask 10 immigration attorneys the same question, you'll get, 7 different answers, 3 of which are correct, 2 of which are wrong, and 2 of which have worked for someone somewhere in the past. And so that's, which I guess, to go back to the first question of the day, is something that adds a little bit of excitement to this. You look at law and everyone thinks law is a science, but it's really an art. And, so be careful with that. Go back, we have a question that kind of relates to this discussion about remote work. Labor condition application postings. With the trend toward electronic posting for LCAs, how are you seeing companies comply with the requirement of ensuring all employees are aware of, the LCAs are posted for the company? How are they handling these communications? So, this is, and it's kind of an ongoing potential issue is, how do you notify everyone, especially if everyone's working? And so companies will, they'll have it on their kind of internal website somewhere that, it is accessible to everyone, be it a link or a data page through human resources. So it is available to everyone in the company, shall they decide to, make the relevant inquiries. And you should be fine as a company if you continue to do it that way. And that's really no different than, the way that doing physical postings, because as you have these LCA and perm postings in break rooms or near the copier machines or printers or whatever, public areas. No one really looks at those anyway or understands what they are for the most part. So, so in some ways, having these electronically available is actually, in my opinion, makes them more accessible to people who may be interested. So H-1B cap, yes. We are in H-1B cap season. And in some ways, this is kind of a weird season in terms of we're doing our H-1B cap season the same time that many companies are engaged in widespread layoffs. As we know, Facebook, Meta, whatever you prefer to call that particular company, announced yesterday or the day before that it's getting ready to lay off an additional 10,000 people on top of the 11 or 12,000 people that they announced the layoff a few months ago. So basically, Meta is planning to shrink its workforce by about 25% in over 12 months. Many of whom, for those of us, such as Andy and myself and many people here that are very active on LinkedIn, you can see lots of discussion, painful discussion of H-1B employees losing their jobs. But at the same time, at least what we're seeing equal to or greater than volume of new H-1B registrants this time around. So yeah, companies are, laying off lots of their H-1B employees, at the same time entering the same number or more people in this year's H-1B lottery. So I anticipate that we're definitely overall not going to have less H-1B registrations than we did last year. We'll probably have more. So I would estimate overall nationwide between the U.S. master's degree cap and the regular H-1Bs that we'll see probably around 300,000 individuals registered for the H-1B cap lottery this year. And so last year's acceptance rates for people that were able to qualify under the U.S. master's degree cap was roughly 50%. I don't see that increasing this year, it may even drop. And for those who are part of the regular 65,000 bachelor's degree cap, last year was 20%. I don't see that getting any better this year as well. So a real dichotomy of companies laying off, yet actually adding potential new staff all at the same time. So let's see, got a couple questions here, see if they're relevant to the what about ELCA for third-party work sites? I am of the opinion that for third-party work sites, that those should be physically posted at the work site by that company. But this is an ongoing issue, is that most third-party work sites make it difficult, if not outright refuse, to post LCAs for contractors that are posted there. And in doing so creates massive compliance risks for everyone involved. What's the solution for that? And the only solution is to some third-party some company that has a lot of contractors on site, third-party placement, to basically get nailed as part of a compliance audit and pay a large and read about themselves in a negative way in the Wall Street Journal or the New York Times. Because otherwise, until that happens, these companies have no incentive to do that. They have every incentive to hide the fact that they have staff significant amounts of their operation with third-party contractors. Question here about how do immigration attorneys determine wage levels? I've worked with several law firms, and I've seen that each one approaches it differently. Wage level 4 is defined by one firm as bachelor's plus 5, while another firm defines it as bachelor's plus 8. And the answer is that there's actually a very rigid formula that's set out by Department of Labor that if you go on, I think it's flcdatacenter.gov, you can see how it works. But it's rigid, but it's confusing all at the same time. So basically, you have this worksheet, and what's the SVP or specific vocational program or something to that effect for the particular job. Then that gets assigned a value, and then what's the job zones at 1, 2, 3, 4, 5? Then that gets assigned a value, and then what degree does a person have, and how much of experience. And so, it does produce some strange, MS plus 3 or bachelor's plus 5, if you do it correctly, that's actually adds up to a wage level 2, not a 4. So the thing is that you could do that calculation to the best of your ability. But it doesn't matter for perm applications, whatever the requirements are stated on the prevailing wage request, Department of Labor will assign the wage level. So in some ways, you have no control on the perm side. Now for non-immigrant visa applications such as H-1Bs or E-3s that do have an LCA requirement, again, it's kind of an art, not a science to a certain extent. It's best practice to not necessarily do that on what the job requires, but what the employee that's being sponsored for the H-1B or E-3 has. So if your H-1B employee has been on an H-1B for 10 years and has a master's degree, then you think about that's probably a barely minimum level 2, and probably needs to be a level 3, if not level 4 employee, not based upon what the job is, but what that particular employee brings to the table. Whereas for the perm process, it is based on the requirements for the job, and Department of Labor will make its own assignation based upon that rigid formula. Marissa, but DOL is giving us level 4 for MS3, BS5. Yeah, no, that's we're starting to see more of that, and to me in the real world, someone with an MS3, BS5 should be level 4 to begin with. You could, if you wanted to, challenge those prevailing wage determinations based upon the fact that they're not following their guidelines. But as we know, it's taking Department of Labor 6, 8, 9 months plus to issue a prevailing wage. So if you challenge that, it's probably going to take around the same amount of time. So unfortunately, you're probably, from a practical perspective, stuck with that. So issues of layoffs. So question, is anyone dealing with layoffs impacting their perm programs? How are you communicating and navigating this issue? Knock on wood, I'm fortunate that none of our client base has yet to have any widespread layoffs. The layoffs generally seem to be concentrated among the really, really big companies and programs. And what we've seen some of the companies do, Google's already made this announcement that because of their large-scale layoffs, that they're basically putting their perm program on hold for 6 months because, under the Worker Adjustment, Retraining, and Notification Act, or WARN Act, you're supposed to give if you're doing large-scale layoffs, workers 60 days advance notice before the layoffs actually happen. And so if you're triggering the WARN Act and then you're turning around and filing, which requires notification to Department of Labor, then if you're turning around and filing lots and lots of perms to the Department of Labor, Department of Labor is going to probably justifiably ask some questions about those perms. So companies are going to be forced to kind of slow down their overall perm programs for a while, for 6+ months or so when they're in a layoff situation. With some strategic lawyering, a blanket should not be necessary. You could probably still find plenty of perms in the pool based upon the specialty nature of the position, where you can still credibly do a perm application. And what concerns me is that companies will probably just stop initiating perms because of layoffs. That's actually very counterproductive and self-defeating to your employees in the long term, because as I mentioned a couple minutes ago, with prevailing wages taking 8 to 9 months before you can even realistically start recruitment and then even get around to the perm, you're looking at between prevailing wage time, recruitment time, a minimum of almost a year from the time you initiate a new perm to the time you can actually file it. That's 12 months from now is going to be a much different employment situation than it is today. So if you delay initiating perms on the which are, future related applications on the basis of what's happening today, that just delays, how long it takes for many of your employees to establish priority dates to get in line for the green card. That increases employee dissatisfaction, and then they're going to start jumping to companies that are going to initiate green card processes for them much earlier than your company. So there is a danger of overcorrection for companies that put their perm program on because of wide-scale layoffs. But this creates an opportunity for companies that are not engaged in widespread layoffs. Now you can go into the H-1B transfer market and probably pick up some really talented, experienced individuals that may not have been available to your company, in the past 2 or 3 years because the job market was really hot. And if you haven't had layoffs and are still doing perm program regularly, that also becomes a very positive recruitment tool for companies to use. So, every time there's chaos for one, there's opportunity for another. And if your company is not in a layoff situation, then you basically now have the ability to open up your recruitment pool. So let's see. Green card application process. I mean, everything's been taking, as we all know, everything's been pretty much taking a lot longer. Department of Labor effectively, at least their perm division, effectively went on hiatus during COVID and have created a very, very, very large backlog for themselves, not only in prevailing with perm processing as well. And we're getting perm approvals for cases submitted in June 2022. So basically, that's almost like a 18 to 21 month life cycle for a perm to get approved. And that's not what the perm process was supposed to be. Like everything that the government sells, especially in immigration, the perm process has been around for 18 years now, and it was sold as well. So if you go to this electronic process, then we'll be able to process these perm applications in 30 days. That's never happened, and if it takes 9 months to produce something that's review something that's electronic, then they might as well just go back to the paper process that they had before. I don't see that, unfortunately, improving at the Department of Labor anytime soon. And so there's a lot of discussion on the immigration lawyer chat rooms of suing the Department of Labor under what's known as the writ of mandamus process, which writ of mandamus is basically a fancy term for suing the government for taking too long to make a decision on your case. And so given the increasing intensity of the chatter related to mandamus against slow Department of Labor processing and the general frustration with that, I would not be surprised to see some writ of mandamus challenges here in the very, very near future. Got a question here. Have you heard of any challenges that companies are facing due to having to post wages because of the California and New York wage transparency laws? Not yet, but the good thing is that as we've been submitting advertisements to our companies for the perm process, the advertising companies are reminding us, hey, you need to have a wage level on there before, and so if we don't have it on the ad draft, they remind us, and so we put it on there. So we haven't had any challenges yet because, we haven't gotten to the point yet where the perms can be filed. But, we're making sure, and our ad company is reminding us to make sure that these wages are included in the ads to avoid this particular issue. And outside of this firm, I haven't heard of any issues yet. So, interesting question. Are you aware of any advocacy to perhaps remove the perm process from the green card process? I have not, and this goes back to my initial opening statement that the perm process is effectively structurally no different than the labor certification process from 200 years ago in the U.S. So I don't see that changing. What I do see is that this is mostly individual driven, although some companies are looking at this of increasingly, okay, well, what employment-based categories can the employee qualify for that do not require a perm process? And there's a few, so there's actually two EB2 sub processes that do not require, that avoid perm. One is called the national interest waiver. The other one is called alien of exceptional ability. Those can be handy in some instances. However, if I were to criticize people I see on immigration attorneys I see on LinkedIn and other places, is a lot of people oversell the ease of which you can get an alien of exceptional ability or national interest waiver approved. So it can be handy, but the requirements are pretty stringent. Otherwise, to avoid the perm process, you could have someone in the EB1 category, but that requires either someone who has A, so-called extraordinary ability in their field of endeavor, or B, if they're engaged in a research occupation, or C, if they're a multinational manager or executive transferee. Those are the 5 primary ways that employment-based immigrants can avoid the perm process. So I haven't heard of any formal movements in that direction, and I would not, unfortunately, Denisa, anticipate anything in that direction as well. As we know, the H-1B cap has been a real headache for a long, long time, and we've also seen increasing restrictions and problems L1 side. So it's led many companies to look at the so-called B1 in lieu of H-1B process as a way of bringing employees over from overseas for short-term projects. Now, the B1 in lieu of H-1B kind of works theoretically, but it's not an actual visa category. The B1 in lieu of H-1B is kind of a made-up discretionary visa realm by Department of State, where if the employees overseas meet certain criteria, they may, by their own discretion, issue the B1 visa. And so basically what they're looking for is, okay, has this person been working for the overseas company for, a certain amount of time? The phrase is customarily employed. Are they on the overseas payroll? Will they continue to be on the overseas payroll? More importantly, do they have some sort of, almost like the L1B, do they have some sort of specialized knowledge process that they need to come to the U.S. and still for a project that lasts less than 6 months? And also, then important, they have to show that there's no immigrant intent. Various consulates are very, very reluctant and have been for a very long time to issue B1s in lieu of H-1Bs because they recognize exactly what it is. It's a way for companies to serve H-1B, the regular H-1B and L1 processes. So you can try it, but it's, the prospects of success are not particularly high, especially if you're trying to do this through any of the consulates or embassies in India or China or other places. You do see some significant variance in approval rates from countries to countries. Let's see what else we got here. Question sort of related to the B1 in lieu of H-1B. So we had a project to hire specialized technicians in Mexico for U.S. projects. Is that possible? Considering some will be new hires, some will actually be, already work for the company. How to handle that? So this particular company might have a blanket L1 petition in place. So if the company does, then that might be option one of transferring employees to the U.S. under this scenario. Option two, since we're dealing with transferees primarily from Mexico in this scenario, we may also look at the TN visa for under the NAFTA category. Because we tend to think of TNs in the context of employees, transfers coming down from Canada. But let's not forget that Mexico is a signatory to the NAFTA treaty and also is TN eligible as well. So, so in this scenario, the company has at least two potential options, either the TN or the L1B. Oh, another question related to H1B cap lottery. I heard the cost will increase significantly for next year's H1B cap lottery. And yes, unfortunately, that seems to be the case. So it's not just going to be for the H1B cap lottery, it's going to be for everything. A couple months ago, USCIS put out a proposed new fee schedule for notice and comments. And they're proposing to significantly increase all the filing fees across the board. The blowback from this has been very, very strong and very, very negative. I saw an article today that Democratic Congresspeople were complaining about how the filing fees for family reunification cases are going to increase significantly as well. But in terms of H-1B cap, as of today and tomorrow, the registration fee is $10 per employee. So very cheap. I mean, and why not? Just entering some information onto the USCIS website and hitting send, and then their computer does the lottery. $10 seems appropriate to me. However, in the fee proposal, the proposed increase was from the current $10 to $215 per employee just to register someone on their website. Absolutely ridiculous. And I believe, I forget the figures, I don't have them in front of me, but for regular H-1Bs, right now there's 3 to 3, sometimes 4 processing fees you have to pay, depending if you do premium processing. So, $460, $500, $1,500, and $2,500, so almost $5,000 in filing fees. Companies can expect to probably see that go to like 12 or 13,000 if you do premium processing per new H-1B. When is that going to go into effect? It hasn't been finalized yet. My guess is that'll probably go into effect sometime in September or October. And the final prices have not been announced. There could be, based upon the criticism, they could reduce those fees. But whatever they end up being, they're going to be, companies are going to have to start planning ahead and budgeting that they're going to get hit with a significant fee increase for all their immigration-related processes. And so, $10 to $215 just to register someone. And so you can just think about how it's going to apply across the board. And I think someone asked a question about, predictions for CIS. And so this just goes to show like how badly mismanaged USCIS is. I mean, USCIS is largely funded through user fees. They don't receive too much from the U.S. Congress in terms of appropriation. So they basically have to generate all their own income, and they do it through fees. And so the incentive is for them to just take in these huge fees, but it doesn't actually. They have to justify their fees to Congress at some point to say that, okay, if you're going to charge $5,000 for an H, you have to show how you put $5,000 worth of work into the H-1B. Well, how do you do that? You do that by taking longer, by making it more difficult, more, steps in the adjudication process. Basically, you are creating a situation where where you're penalizing yourself if you're too efficient. Inefficiency is is actually the key here, And I think back to when I started in this field, September 1998. The filing fee for an H-1B was only $85, and you wrote the check for $85, and if you filing your H-1B in the Vermont Service Center in those days would issue a decision in 3 weeks. $85, 3 weeks. Now, if you skip premium processing and you don't have to pay the job training fee or the anti-fraud fee because you've done renewals, and you only have to pay the base $460 fee. If you spend that $460 to the Vermont Service Center and don't premium process, it's probably going to be not 3 weeks, 4, 6, 8, 10 months before they issue a decision. So in 25 years, the base fee for the H-1B has increased by 500%, but so has the processing time. And so, USCIS will sell this. We need all this money so we can operate better. But, there's almost, over the years, a one-to-one correlation between every day increased fees and how much longer everything takes. So that's, those incentives, our structure is never going to change unless the U.S. Congress starts funding USCIS through appropriations and not user fees. But with that, I want to have some positive news. So we have a question here about current USCIS sentiment while adjudicating cases. We have seen over since the Trump administration departed back in January 2021, and even a little bit before that, and seen the trend line continue, we've seen the adjudication environment around H-1Bs and L-1s significantly improve. We've seen, for a while there during the Trump era, we saw, RFE rates skyrocket significantly. We rarely see RFEs these days for H-1Bs and L-1s. Definitely haven't seen any denials recently. The RFEs that I do see, that I read through them, and I think, oh, okay, this actually, for the most part, makes a lot of sense. It's actually, I don't agree with it, but it's on point. So we have noticed a trend of not only more favorable adjudications, but better quality adjudications as well. So I will give credit to USCIS for kind of cleaning up its processes in that regard. But there was a question about what can explain excessive delays in processing I-539 applications by USCIS. So just for those who don't know, an I-539 is the form number for that dependent family members file. So for either their H-4 or their L-2, or if they're in the U.S., their TD, or whatever the case may be. And so during the Trump era, and actually all the way through coronavirus, the 539 processing times became ridiculously long. And part of the reason why is that USCIS used to keep the H-1B and H-4 and the 539 together and adjudicate it at one time. And so if you premium process the H-1B, they would kind of de facto premium process the H-4 as well, because there's not that much to an H-4. It probably takes them 10 minutes at most to adjudicate. So it wasn't much effort, but for reasonably intentionally slow down the process, USCIS at some point started separating the adjudication of the H-1Bs from the H-4s, the L-1s from the L-2s, and with that, it just increased the processing time significantly. While there are still some cases out there that have been around for a very, very, very long time. Sorry, I'm not being rude and checking my phone, but one of my team members needs me to send them the our USCIS account login information because I guess they want to submit some registration. So apologies in advance. Bear with me 1 second while I send this to my colleague Jennifer. Done. Hopefully the USCIS website won't crash or lock out, because that's been just like every other CAP season where we've had this electronic process. USCIS website, it's almost kind of like they're run on an old 386 processor, like a one computer server. Definitely not robust. If too many people get on it, the whole thing crashes. It's kind of a joke, but it is what it is. So what do I see for trends for the remaining part of 2023? Definitely, I see some movement toward greater transparency and clarity from USCIS, like we have been seeing for some of their policy issues. I don't really foresee much happening positive in EB2 or EB3. Obviously the layoff dynamic creates issues on the non-immigrant visa side and the perm side that we'll have to work through. The situation's never perfect, but then the overall situation, as I see it, is significantly better than it was in, say, 2017, 2018, and hopefully that will continue. So it definitely feels better practicing immigration law in 2023 than it did in 2018, because those are some really bad times. But hopefully they will continue. So there was a question, I don't know if Amy Spiker from Eaton, if you're on the call, but contact me separately, and I'm happy to send you a template draft immigration policy that you can take a look at, and happy to discuss anything that can tailor to your particular company and company's needs. And I'm looking at my list here, and I think, Andy, I think I've covered everything that was submitted in advance, either directly or indirectly. Okay.
Thanks. I think.
Yeah, I've been kind of doing that as we go through. Let me just scroll through, see if I've missed any. Let's see. Okay, dealt with the electronic LCA posting issue, remote perms, wage levels. Yeah, I think I covered everything in the chat. Do one last sweep of your company to see if there's anyone that hasn't been brought to your attention that needs to be entered in the H-1B cap lottery. This happens every year. You start the notifications, hey, we have to do this in March. You start that around Thanksgiving, and you get some names, and who is still at the company that didn't get selected last year, and then maybe you have some sort of insight as to new people. But every year there's always hidden interns, hidden F1 OPT people that kind of appear at the last minute. So this is your time to send out your last call email, as if it doesn't happen today or tomorrow, then it's not going to happen for another 12 months, unfortunately. Basically, I think the upcoming fee increase is definitely something that needs to be on everyone's radar. We know it's coming, and we know it's going to be painful. So to the extent that companies can file, non-immigrant visa extensions in advance, obviously you can't do it more than 6 months prior to expiration of the person's current expiration, but try to file those as early as possible to avoid the fee increases. Yeah, and to me that's the major thing to look out for. Otherwise, everything else, priority date movements for EB2, EB3, acceptance rates for H-1B cap, that's unfortunately that's all out of our hands and out of our control. Oh, so I'm not sure, but when do we expect the fees to increase? Good question. It hasn't been announced. My prediction is probably September, October timeframe. But whenever that's announced, we'll have it probably 30 at most 60 days advance notice. So yeah, I'll just say that this layoff situation was something that here at Meyer Law Group we kind of knew was coming. We had our clients, many of whom, in this time 12 months ago, 12, 18, 24 months ago, were doing significant numbers of H-1B transfer cases, new blanket L cases, initiating green card processes very early. Then one day, all that pretty much stopped. Stopped seeing lots of transfer activity. People were there, started delaying longer, initiating green card processes. And then we saw, okay, companies that were paying and used to pay traditionally in 30 days are now paying in 45 days. 45-day payers are now paying in 75 and down the line. So what does that mean? That means that companies are stopped hiring and hoarding cash. Well, if you stop hiring and hoarding cash, what's the next logical step in that sort of process? It's laying people off. So unfortunately, not a surprise. Spotting those trends in advance. We can't really go out and tell everyone, hey, the layoffs are coming. The layoffs are coming. You need to do this because no one wants to hear that type of advice in advance. Especially if it turns out to be wrong. Because the joke is that economists have predicted 32 of the last 7 recessions, and and that record of being wrong will likewise continue. So, this is a process. This is probably, the fourth or fifth one of these downturns that I've experienced in my career. They're obviously unpleasant, but it takes about 12 to 18 months to work through it, and then we have good times again, and the cycle repeats itself. So, Andy, if we do this particular event again in October or 12 months from now, we might be in a completely different scenario. The questions in the chat might be, "Oh my God, we can't find people fast enough. What's going to be the prospects of H-1B cap relief or something else?" And and hopefully we'll be there. No, I just appreciate everyone taking their time during our H-1B busy season to ask their questions, and hopefully people found the discussion here useful. If I was unclear about anything, or anyone has any follow-up questions, I see Andy, you've posted my contact info in the chat a couple times. Thanks for that. Reach out to me at your convenience, and I'm happy to have a conversation with you.